how to use your own state's bar rules as leverage to get paid in personal injury. So if you have attorneys that are, messing with you, trying to not tell you what the disbursement sheet was, how much money was collected, who the other providers were, we're going to talk about how to handle that. How are you going to get your full bill paid? So knowing your communications, knowing how to negotiate, knowing the leverage points to compel these attorneys that you mean business and you're not somebody that can walk over in this personal injury game. Do you know the leverage points to get them to pay you the maximum amount of your bill while still maintaining the relationship? You've released a patient, a year has gone by, you sent the patient's bills, notes, records to the attorney a year ago and you're waiting to get paid. And then you get a phone call. We're gonna give you two scenarios here. One of those phone calls is, hey, Dr. Slater, I know your bill was $4,000 on Mrs. Jones. Will you take $1,000 on the case? So there's three questions that you're gonna ask. The first question is, oh, well, my full bill is $4,000 and you're asking me to make a business decision. I make business decisions based on data. So I'm gonna need some things from you. The first thing I'm gonna need is, well, I'm gonna save that for last. One question you can ask is, did you use my full $4,000 bill to get this settlement, or did you only use 25% of it? You already know the answer. They used your full bill, number one. Number two, did that patient, your client, authorize you to short pay me? Did they do that? They didn't, right? You already have them locked down with your assignment of benefits, power of attorney. They've signed away, they've signed your lien in your office. They didn't authorize a short pay. The third question, and this is important, you got to know your state bar rules, right? Mr. Attorney, I make decisions based on data. I need more data. So I'm going to ask you to share the disbursement sheet with me. I want to know who all the providers were, and I want to know what the settlement offer is, because I want to know that I'm being treated fairly, and I would just like for you to be transparent with me. Ask them for the disbursement sheet. Now, here's what's going to happen in some cases. Some attorneys will go, well, that's attorney-client privilege. I really can't share that with you. No, you've signed a two-way HIPAA-compliant thing. It's not doctor-client or doctor-patient confidentiality. You shared all the medical history with that attorney. That is a tactic they use to get out of paying you. But here's how you handle it. Mr. Attorney, according to the Georgia State Bar Rule 1.15, the safekeeping of records, if a person or a third party has an interest in the case, and in this case, my bill is my interest, you have to provide me a full accounting upon request, and I am now making that request. What say you, Mr. Attorney? That's in your state bar. That generally gets a check in your inbox or in the mail at the end of the week, right? Because you're just going to say, well, we'll just see what the state bar has to say about that, right? So that's how you use the bar rules to get paid. If you have a good relationship with the attorney, it shouldn't come down to that. But here's what you can do. Now, I know in Georgia, it's State Bar Rule 1.15. Perhaps you're in Florida or Kansas or Arizona or Texas, and you don't know what that is. You can go to artificial intelligence, ChatGPT, and ask it this. I'm looking for a similar bar rule in the state of Kansas that's similar to American Bar Rule 1.15, the safekeeping of records. Please tell me what the applicable bar rule is in my state. Enter. And let artificial intelligence find you the chapter verse of safekeeping of records of American Bar Rule 1.15. And then you can go to your state's bar association, go to their website, look it up, copy it, paste it, learn it, understand it, know it. Now, in most states, they have to provide it upon request. Some states, the language is kind of vague, but you can still threaten a bar complaint. An attorney can be disbarred in Georgia if they don't share that disbursement sheet. Okay, so that's one scenario during negotiations. The second scenario is this. Let's say you call, it's been 2 years since you released the patient, you call the attorney firm, hey, I'm looking for a status update on Miss a Miss Watkins case, and the attorney doesn't call you back, or they're hemming and hawing, and then maybe you call Miss Watkins, and Miss Watkins says, "Oh, I was paid 6 months ago. I got $40,000 on this case." "Oh, really?" That is a situation where the attorney can lose their bar license because they are not allowed, because it's safekeeping of records, they have to keep that in a non-interest bearing account until the case settles. And if they paid the patient before they negotiated and paid all the doctors, you're going to file a bar complaint. And I know that this just happened because one of my clients did that in the state of Tennessee, right? They threatened to file a bar complaint, and they did file the bar complaint. Actually, this law firm, let's call them Florgan and Chorgan, didn't want to pay and called their bluff. Said, "Go ahead, we don't care. We bet you're not going to file a bar complaint." Well, he did. He had a chiropractic and PT bill that was $10,000. That was his bill, full bill for chiropractic and physical therapy. The state bar reached back out to him, real long letter, says this is what's going to happen. That attorney not only has to pay your full $10,000 invoice, but they have to pay 18% interest for the past 2 years that you haven't been paid. Plus, this attorney, this chiropractor, he hired an attorney just to help him through this process. That attorney tacked on 30% attorney's fees. So that attorney firm, Florgan and Chorgan, could have just paid the $10,000 like good people. Instead, they had to pay $20,000 and they had to deal with a bar complaint. Okay, so if you know the state bar rules and you know exactly what they are, you can use those as a leverage point to get your bill paid. Now, if I was this doctor and he says, "I don't want any more patients or clients from Chorgan and Florgan because I'm not looking to work for free. I'm not looking to work for 20, 30 cents on the dollar, or essentially work for free. So I don't care if I never get their clients again. There's thousands of attorneys in your city. Go find and work with them." Secondly, Florgan and Chorgan are so big, the left hand probably doesn't know what the right hand is doing. He still may get referrals from them, knowing that if he has a $10,000 bill, not only is it possibly $10,000, it could possibly be $20,000, but it's happened in the past, and one of my clients, that is exactly what happened. So again, know your state's bar rules as it pertains to the safekeeping of records, and just learn it, know it, and use it as leverage in your negotiations with attorneys, because attorneys don't want a bar complaint. They have to answer it. And you never know what the bar can say. The bar can get really mad and go, this guy's not doing the right thing. We don't want him in our state bar anymore. And they can revoke his license and just bar him. Again, go to ChatGPT, type in, "I'm looking for the applicable state bar rules in the state of Florida that is similar to American Bar Rule 1.15, the safekeeping of records." Let ChatGPT tell you what it is. Go to your state bar's website, look it up, find it, know it, and use that as leverage to get paid on your personal injury case if it comes to that. Don't get rolled over and not know what to do and take 20, 30, 10% of your case fee. These attorneys are using your bills and records to get that settlement. Secondly, on your $5,000 bill or $4,000 bill, if that's your average case fee, you know what the average attorney gets on a PI case? $26,000, right? So as chiropractors and other physical medicine doctors, a lot of us, we just hit singles all the time. Attorneys can hit home runs. So let's protect our bill. Don't feel sorry for them. Get what you deserve, but know the leverage points, know your state bar rules. It's American Bar Rule 1.15, the safekeeping of records. Go find out what that similar bar rule is in your state and use it as leverage to get paid. I'm not saying you want to threaten every attorney who you deal with, because hopefully you have better relationships with that. But if you have one or two of these outlier attorneys, hold their feet to the fire, said, well, let's just see what the state bar says about this. I didn't say I'm going to file a bar complaint. I'm going to say, let's see what the state bar has to say about this. As far as you're not threatening them, you're not extorting them, you're just saying, hey, I'm going to do some research and see what it says. The attorney go, yeah, go ahead. Hopefully I'll never hear from you again. And they got slapped pretty good. So I hope you got a lot out of this meeting today, knowing the 3 questions to ask. Did your client advise you to short pay me? Did you use my full bill to get this settlement? And I need to see the disbursement sheet in order to make this business decision in order to get this bill paid. If you're in YouTube, like and subscribe to my YouTube channel. I produce a long form video every single week that pertains to personal injury to help you move the ball down the field, help you be a better marketer, a better negotiator, and to help you build a better personal injury practice. Again, I'm Mark Slater of Prime Spine Consulting. Thank you so much for attending today. See you next time.